In this lecture, I will discuss the topic under the Transfer of Property Act 1882. This topic is relating to duties of seller of immovable property, fraud committed by seller, and rights and remedies of civil nature available to the buyer. I am discussing this topic on the background of one judgment of the Honorable High Court. This judgment is given by the High Court in the civil revision petition. The parties before the High Court are Ganpat versus Mangilal. Here that applicant Ganpat is a seller of one house property. Ganpat is a seller, and that Mangilal is the buyer of that house property. So in this case, seller versus buyer. So in this case, that Ganpat sold one house property to the Mangilal, but that house property was already mortgaged. Then the property in whose favor it was mortgaged, that person is called mortgagee. In this case, one Mishri Lal is the mortgagee, and that house property was already mortgaged in favor of that Mishri Lal, who is a mortgagee. And such mortgage property is sold by Ganpat to the Mangilal, who is a buyer. But the sale deed which was executed by Ganpat in favor of Mangilal for the sale of that house property, in that sale deed there is a clear recitals to the effect that property which is subject matter of sale is not subject to any encumbrances. It is not encumbered. It is not subject to encumbrances. But this statement in the recitals of the sale deed is clearly false, because that house property is already mortgaged, and that statement in the recital of the sale deed is false. The fact of it is also known to the seller Ganpat. That means that Ganpat, who is the seller, he is having clear knowledge that whatever statement is made in the recital of the sale deed to the effect that that property is not subject to any encumbrance, that statement is clearly false. It is known to the seller. Then in the meantime, that mortgagee, he has a filed suit in the court for the enforcement of the mortgage, and in that suit, that seller Ganpat was also defendant, because he was the transferor. That mortgage suit was decreed, suit for enforcement of mortgage, and accordingly, for the realization of the mortgage debt, that house property was sold by the order of the court. But it resulted into the consequences that the plaintiff, who is a buyer of that house property, he was dispossessed from the house. Plaintiff was dispossessed. Therefore, the plaintiff has filed this present suit before the trial court for the recovery of purchase price which he had paid to the seller for buying that house property. So this Mangilal, who is a buyer, has filed a suit for recovery of or for refund of purchase price, and also for the damages. Then the trial court decreed the suit of that buyer Mangilal, against which that seller Ganpat made appeal in the appellate court, that is district court. District court upheld the decree of the trial court with respect to the refund of purchase price, refund of that purchase price. But appellate court said that there is no order for separate order for damages, but appellate court only upheld the order of trial court relating to refund of purchase price by the seller to the buyer, that is by defendant to the plaintiff. Against this order, this defendant, that is seller Ganpat, has made a revision application before the High Court. This present revision application before the High Court. It is a fact that the sale deed contains a recital by the seller Ganpat that the property which is sold by that sale deed is not subject to any encumbrances. But this statement is absolutely false to the knowledge of Ganpat seller. He is knowing it. Before the High Court, the learned advocate on behalf of the seller Ganpat made two contentions. First contention is that because the mortgage deed in favor of Mishri Lal was registered, it was possible for the buyer Mangilal to find out the existence of the mortgage with ordinary care, because the registration of the deed amounted to a constructive notice under section 3 of the Transfer of Property Act. Buyer should be deemed to have known about the mortgage. Accordingly, that learned advocate on behalf of the seller Ganpat contended that clause A of subsection 1 of section 55 of the Transfer of Property Act did not apply to the case. So what was the contention on behalf of the Ganpat seller before the High Court? That although that property is already mortgaged, it was mortgaged by a registered deed of mortgage, and therefore even though recital of that sale deed contains recitals of that sale deed says that property is not subject to any encumbrances, then also, since because that property was mortgaged by a registered deed, therefore the buyer could have discovered this fact with his ordinary care and diligence, and besides that, registration of deed amounts to a constructive notice. So what is constructive notice? This term constructive notice is defined under section 3 of the Transfer of Property Act. It says that a person is said to have notice of the fact. That means a constructive notice. Constructive notice means it may be that in reality actually the person is not having knowledge of any particular fact. Then also circumstances are such that law presumes that such person is having knowledge of that fact. Means even though in reality a person is not having a knowledge of that particular fact, then also law presumes that such person is having knowledge of that particular fact. So it is a constructive notice. Registered document amounts to constructive notice. Why? Because registered document, its copy is kept in the office of registrar, and any person can have access to such document. Any person can obtain the certified copy of such document. Any person can know the information contained in that registered document. So now it has since because of the registration of that document, such document now become a public document, and so any person who is interested in that matter can see that document, and therefore registration of document amounts to constructive notice. So it is the contention of that advocate on behalf of the seller, and therefore it is a contention of that advocate on behalf of the seller that clause A of subsection 1 of section 55 of the Transfer of Property Act did not apply to this particular case. So what is that section? Section 55. Section 55 of the Transfer of Property Act, it is a very big section. It mentions the rights and liabilities of the buyer and seller. Its subsection 1 talks about the duties of the seller of immovable property. So section 55, subsection 1, duties of the seller. That subsection 1 contains various clauses, clause A, B, C, D, E, F, G. So first clause A. The clause A says that the seller is bound to disclose to the buyer. Seller is bound to disclose to the buyer any material defect in the property, or the seller is bound to disclose to the buyer any material defect in the seller's title to that property. Seller is bound to disclose to the buyer any defect in the seller's title to that property of which the seller is aware but the buyer is not aware, and which the buyer could not with ordinary care discover. So seller is bound to disclose to the buyer any material defect in the title of the seller. But the fact of such defect, it is known to the seller but not known to the buyer. But it further says that even though it is not actually not known to the buyer, but fact is such that it can be discovered by the buyer if he could have shown some ordinary care for the discovery of it. So there are two parts of this clause A, and therefore it was the contention on behalf of the advocate of that seller before this High Court that even though that fact of prior mortgage was not disclosed by the seller to the buyer, then also it could have been discovered by the buyer with the ordinary care, and therefore in this case clause A of subsection 1 of section 55 do not apply. Regarding this contention, High Court observed that so far as the applicability of this clause A of subsection of this section 55 of the Transfer of Property Act is concerned, so far as applicability of this clause A is concerned, the contention of the advocate on behalf of the seller appears to be correct, because High Court observed that to attract the provision of this clause A, subsection 1, section 55, to attract the provision of this clause A, two conditions are necessary. Firstly, that the buyer could not be aware of the existence of the defect in title. The buyer should not be aware of the existence of the defect in title. And secondly, that buyer could not with ordinary care discover the defect. Means buyer should not be aware of the existence of the defect in title, and second condition that buyer could not with ordinary care discover the defect. But in our example, the fact of that prior mortgage could have been easily discovered by the buyer if he had made a search. Therefore, in this case, the second condition is not satisfied, because the buyer could have known about the prior mortgage by making inquiries in the office of registrar, where documents are registered. Therefore, section 55 subsection 1 clause A of this Transfer of Property Act has no application to the present case. So it is the conclusion of the High Court. Now there is one more contention which has been made on behalf of the advocate of the seller, which has been made by the advocate on behalf of the seller. The second contention is that the contract of this sale was not voidable because the buyer could have discovered the existence of the mortgage, and therefore the case fell within the exception to section 19 of the Indian Contract Act. So it is another contention on behalf of the seller. What is the contention? The contract of sale was not voidable because the buyer could have discovered the existence of the mortgage, and therefore the case fall within the exception to section 19 of the Indian Contract Act. So we will see what is that section 19 of the Indian Contract Act. Section 19, it talks about section 19 of the Indian Contract Act. It talks about voidability of agreements without free consent. Voidability of agreement without free consent. It says, when consent to an agreement is caused by coercion, fraud or misrepresentation, then the agreement is a contract which is voidable at the option of the party whose consent was so caused. So when consent to an agreement is caused by, here we will take the example where the consent to an agreement is caused by either fraud or misrepresentation, then the agreement is a contract which is voidable at the option of the party whose consent was so caused. But there is an exception to this section 19, and this advocate on behalf of the seller is taking help of that exception to section 19. What it says, exception to section 19 of the Indian Contract Act. If such contract was caused by misrepresentation or by silence, if such consent was caused by misrepresentation, then also such contract is not voidable. If the party whose consent was so caused by misrepresentation, had the means of discovering the truth with ordinary diligence. So this section, exception to section 19 comes into picture when the consent was caused by way of misrepresentation. Then also, even though the consent was caused and there is no free consent, then also such contract is not voidable if and when the party whose consent was so caused had the means of discovering the truth with ordinary diligence. And therefore, here the contention of the learned advocate on behalf of the seller, he says that even though seller has not disclosed the fact that house property which he is selling is subject to the encumbrances, subject to mortgage, it is already mortgaged, even though this fact has not been disclosed by the seller, then also it is a such fact that which could have been easily discovered by the buyer if he had made a search in the office of registrar. And therefore, this case falls within the scope of exception to section 19 of the Indian Contract Act, and therefore this contract is not voidable at the option of the buyer. So it is a contention on behalf of the seller. Regarding this contention, it is a conclusion of the High Court that said contention that case falls within the exception to section 19 of the Indian Contract Act is not having any force. So High Court says that said contention made by the advocate on behalf of the seller, Ganpat, that the case falls within the exception to section 19 of the Indian Contract Act, this contention is not having any force of law. Why? Because the express recital in the sale deed about the non-existence of the mortgage was false. So there was an express recital in the sale deed by which that seller had sold that house property to the buyer, that Ganpat had sold this house property to the Mangilal. There is an express recital in the sale deed that regarding non-existence of the mortgage, non-existence of any prior mortgage. But that express recital was clearly false, and it is false to the knowledge of the seller because seller was knowing it. Seller was knowing it clearly that this property is already mortgaged. Then also he made a recital in the sale deed that this property is not subject to any encumbrance. So this express recital made in the sale deed was absolutely false, and it is to the knowledge of the seller because he is knowing it. Therefore, it is not a case of mere representation, but it is a case of fraud as defined in section 17 of the Contract Act. So it is a case of fraud, not a misrepresentation. Fraud as defined in section 17 of the Contract Act, because it was a suggestion as to such a fact of that which is not true by one who does not believe it to be true, and there is an active concealment of the fact by one having knowledge or belief of the fact. So it is a observation of the High Court that this particular case in hand, in this case there is no misrepresentation but there is a clear-cut fraud, and therefore the section 19 of the Indian Contract Act has no application in this case, and therefore this particular contract of sale is voidable at the option of the buyer on account of fraud committed by the seller. So it was the contention on behalf of the seller, on behalf of the contention by the advocate on behalf of the seller that this particular case falls within the exception to section 19, and therefore this contract is not voidable. But High Court has not accepted this contention. High Court said it is not a case of misrepresentation, and the section 19 of the Indian Contract Act especially applies to the case of misrepresentation, but case in hand is not relating to misrepresentation, it is clear-cut fraud which is defined in section 17 of the Contract Act. What is section 17 of the Contract Act? Let's see. Section 17 of the Contract Act, it defines the fraud. Fraud means and includes any of the following acts. Which acts? I will tell. Two important acts are there. Fraud includes any of the following acts which is committed by one party to the contract with intent to deceive another party to that contract. So following acts committed by one party to the contract with intent to deceive another party to the contract. That means fraud. And it includes following acts. Which acts? Making suggestion as to any such fact which is not true. Means making suggestion as to existence of any particular fact. In fact, that fact is not in existence. That means it is not true. But then also making suggestion as to existence of such a fact, certain fact. Who is making suggestion? Who is making such suggestion? By such a person who himself also does not believe it to be true. That means a person making a suggestion knows it. What fact he is suggesting, it is not true. Then also he is suggesting it to be true. So this is a fraud. This is a fraud. The person who knows it, it is not true. Then also he is suggesting it is as a true. The suggestion as to fact of that which is not true by one who does not believe it to be true. And then second act which amounts to fraud, active concealment of fact one having knowledge or belief of the fact. It is other way now. Means fact is in existence. One important fact is in existence. But that one party to the contract, he is also knowing it, that fact is in existence. But then also that one party to the contract is concealing that important fact from the another party to the contract. So active concealment of a fact by person having knowledge about that fact. So this is the fraud. There is one explanation clause which is also important. It says that explanation clause to this section 17 which defines the fraud. It says mere silence as to facts likely to affect the willingness of the person to enter into contract is not fraud. Mere silence is not a fraud unless the circumstances of the case are such that regarding to such circumstances, it is a duty of the person keeping silence to speak, or unless his silence is in itself equivalent to speech. That means in such case, what it says, explanation clause, first it gives general rule. Mere silence is not fraud. But now the circumstances are such that it is a duty of the person who is keeping silence. It is a duty of the person who is keeping silence to speak. And if he keeps silence in such situation, then it amounts to fraud. Or when his silence itself gives some positive suggestion, silence itself amounts to a speech, when silence itself gives positive suggestion, then it amounts to fraud. For example, before entering into the contract by the buyer, if the buyer and seller, if the buyer asks to the seller whether you have clear-cut marketable title to the property, so buyer asks one specific question to the seller, whether you have clear marketable title to this property which you are going to sell to me. And in such a situation, if the seller keeps silence, it doesn't say anything, it means what? It suggests that he is having clear and marketable silence, because here buyer has asked specific question to the seller whether you have clear and marketable title. In this situation, it was the duty of the seller to speak. He cannot keep silence. It was his duty to speak. And if he keeps silence, it means that he is having clear and marketable title. And when it is found that he is not having such clear and marketable title, then he is keeping silence by the seller. It is clear-cut fraud. It amounts to fraud. So here, in this particular case in hand before the High Court said that to this present case, section 19 or its exception is not applicable, but this case, section 17 of the Indian Contract Act is applicable, which defines the fraud. Then what about the remedies? The High Court observed that even though clause A of subsection 1 of section 55 of the Transfer of Property Act is not applicable to the present case, then also it does not affect the right of the buyer to claim compensation for the defective title. So buyer is entitled to claim compensation. How and why? Because in this present case, the appropriate provision is contained in section 55 subsection 1 clause G of subsection 1 of section 55. So the appropriate provision applicable to the present case is clause G of subsection 1 of section 55 of the Transfer of Property Act, according to which the seller is liable to discharge all encumbrances on the property which are existing on the date of sale, except where the property is sold subject to encumbrance. In the present case, the property was not sold subject to encumbrances. On the other hand, it is expressly mentioned in the recital of that sale deed, there is no such encumbrances on the property, which was in fact false recital. Therefore, as per the provision of this clause G, the seller was bound to discharge the encumbrance in favor of the mortgagee Mishri Lal, which was existing on the date of sale. So this clause G is very important. Means in this particular case, even though clause A of subsection 1 of section 55 cannot come to the help of the buyer, then also clause G of subsection 1 of section 55 of the Transfer of Property Act comes into picture in this case. So what this clause G says, it is the seller is bound to discharge all encumbrances on the property which are existing on the date of sale. Seller is bound to discharge all encumbrances on the property which are existing on the date of sale, except where the property is sold subject to encumbrances. So there is an exception also. Suppose the seller clearly says to the buyer, I am selling this property, but it is subject to encumbrance amounting to rupees, say for example 5 lakh. So I wish to sell it subject to encumbrances. Do you want to buy it subject to encumbrances? Then in that case buyer may say yes, but he may also ask to reduce the purchase price by that amount of encumbrances. So here in this situation, buyer can also buy the property subject to encumbrances. But when the case is such that seller is not selling the property subject to encumbrance, and when the buyer is not buying the property subject to encumbrance, then in that case, as per the clause G of subsection 1 of section 55 of the Transfer of Property Act, the seller is bound to discharge all encumbrances which are existing encumbrances on the property which are existing on the date of sale. So in this present case before the High Court observed that now this clause G of subsection of section 55 is applicable to this present case. Accordingly, the liability of the seller to discharge the encumbrance is absolute liability, and it can be avoided only under one circumstances, that is when the buyer has expressly agreed to purchase the property subject to encumbrance. But in our case it is not such a thing, that buyer has not agreed to purchase the property subject to encumbrance. So clause G of subsection 1 of section 55 is applicable to this case. Then it is immaterial here whether the buyer was aware of such mortgage or not. Another thing is there in this particular case in hand. The amount which was secured by the mortgage was higher than the purchase price. So it is not worthwhile that buyer, by paying that mortgage debt to the mortgagee for the redemption of mortgage, this case was not possible because already that debt secured by the mortgage is already more than the purchase price. So there is no question of redemption of mortgage by the buyer. It will be double loss to him. If he compelled to redeem the mortgage, then it will be double loss. So buyers can simply ask for the refund of purchase price as a damages under this clause G. Besides, the claim of buyer can also be supported under subsection 2 of section 55 of the Transfer of Property Act, according to which the seller is deemed to contract with the buyer that the interest which the seller professed to transfer to the buyer subsists in him, and that he has power to transfer the same. This subsection 2 of section 55 is also important. It is regarding implied obligations on the seller. It is also called implied covenants. Implied means that even though regarding that obligation nothing is expressly mentioned in the contract of sale, then also law presumes that that obligation is a part and parcel of that particular contract. That means obligation is always there. Even though it is not expressly mentioned in the contract. So what that subsection 2 says, seller shall be deemed to contract, is a deeming provision. So it is implied. The seller shall be deemed to contract with the buyer that the interest means right title, which the seller professed to transfer to the buyer, that interest subsists in the seller and that he has power to transfer the same. Meaning that for the purpose of selling the property by the seller to the buyer, seller should be absolute owner of that property. Absolute means not subject to any restrictions or conditions. Meaning thereby, if the property which is the subject matter of the sale, if it is already mortgaged, then there is no absolute title because it is subject to restrictions or conditions regarding marketability of the title. Therefore, the subsection 2 says, when the seller attempts to sell any property to the buyer, it is always implied there he is having absolute and marketable title to sell that property. So there is in this present case, High Court says there is also breach of this implied covenant or condition, and therefore buyer is entitled to claim damages from the seller. Therefore, the High Court observed that under section 55 subsection 1 clause G of the Transfer of Property Act, the duty of discharging the encumbrances lay on the seller, and he is responsible for the consequences which are flowing from his failure to discharge this duty. What are the consequences in this case? That buyer was dispossessed of the property because of the enforcement of the mortgage by that mortgagee, and therefore the seller was liable for refund of the purchase price. Seller is liable for refund of purchase price. Therefore, the High Court upheld the order of the lower appellate court High Court, High Court said that the order passed by the lower appellate court is correct. What was the order of the lower appellate court? Lower appellate court accepted the claim of buyer regarding refund of purchase price as a damages, and therefore this present revision petition filed by the seller Ganpat, it is dismissed by the High Court. Recently, another matter came to me for consultation. That matter came to me from the buyer of one house property. Recently, this is another case. So in this case, another case, buyer asked another lawyer to make a title search of the property which he is going to buy, to make a title search and also give a search report. So in this case, which came to me for consultation from the buyer, in this case, buyer asked one lawyer to make a title search and to give search report. Besides that, the buyer also asked to publish a public notice in newspaper to that lawyer. So buyer asked that lawyer to publish a legal notice, to publish a public notice in the newspaper on his behalf before buying that property, asking for any objections regarding this transaction. But in this case, that lawyer was not known to the buyer. That lawyer was introduced by the seller to the buyer. So that particular lawyer was very close to the seller, and he was not known to the buyer. Seller introduced that lawyer to the buyer. That lawyer was very close to the seller. So that lawyer gave one search report. That lawyer gave one search report in which it is clearly mentioned that that particular house property which buyer is going to buy, it is free from encumbrances and seller has marketable title to that property. So it is clearly mentioned in that search report. But this search report was absolutely false search report, because that particular house property was subject to encumbrance and it was already mortgaged with one bank. But buyer was not knowing about this fact. Therefore, he asked the lawyer to make a search report. But that lawyer gave him false search report. But the buyer relied upon that search report because it was made, after all, it was made by the lawyer, who is the expert. And therefore, that buyer purchased the property at a market rate. He purchased that house property at prevailing market rate. Later on, when the mortgagee bank issued one notice to that buyer, then only said buyer came to know about the fact that house property is already mortgaged in favor of that bank. That house property which he has purchased, it is already mortgaged in favor of the bank. So this fact came to know to the buyer when that mortgagee bank issued a notice to the buyer. It was also issued to the seller. Now, we have to consider in this case, now can we take the help of clause A of subsection of section 55 of the Transfer of Property Act? Because that already discussed case which was before the High Court, in that case High Court held that clause A of subsection of section 55 was not applicable to that particular case. But here in this case, whether this clause A of subsection of section 55 is applicable? So answer is yes, it is clearly applicable. Why? Because the buyer has made all those necessary things which he can, in the ordinary course he can do it, all such necessary things to find out marketable title of that property. What necessary things he has done? He has approached a lawyer, he asked him to make a title search of that property. He asked even that lawyer to publish one public notice in the newspaper inviting any objection regarding transaction of buy and sell. So he has done everything. What is expecting him in ordinary course. But then also that buyer was get defeated, he was get defrauded. But in this case, why this was happened? Firstly, I am telling about in this case clause of subsection 1 of section 55 is clearly applicable, because buyer has made every attempt to discover whether the seller is having marketable title. But then also he was get defrauded and cheated because of the false search report made by the lawyer. So in this case, this buyer is also entitled to claim damages and refund of purchase price even under this clause A of subsection 1 of section 55 of the Transfer of Property Act. Considering this case before me, it is my conclusion that now it is very necessary for a common man that if you wish to obtain the search report of any property which you plan to buy, then firstly make the proper search for good, learned and reliable lawyer. So I stop here. Thank you.